Regulation of the Head of the National Police of the Republic of Indonesia. Number 6 of 2019. About criminal investigation. With the grace of Almighty God, Head of the National Police of the Republic of Indonesia. Way, that in carrying out law enforcement duties, the National Police Investigator of the Republic of Indonesia has the duty, function, and authority in the field of criminal investigation in accordance with the laws and regulations, which are carried out professionally, transparently, and accountable to every criminal case for the realization of the rule of law that reflects legal certainty, sense of justice and expediency, be that in order to meet the needs of the organization of the National Police of the Republic of Indonesia and the laws and regulations on which the investigation is based, there are still shortcomings. It is necessary to make implementation instructions regarding criminal investigations so that the investigators of the National Police of the Republic of Indonesia can carry out their duties, functions, and authorities professionally, transparently and accountably. C. That based on consideration as referred to in letters A and letter B, it is necessary to establish the regulation of the head of the National Police of the Republic of Indonesia regarding the investigation of criminal acts. Considering Law Number 2 of 2002 concerning the National Police of the Republic of Indonesia, Statute Book of the Republic of Indonesia No 2002/2002, Supplement to Statute Book of the Republic of Indonesia Number 4168. Decide. Stipulate regulation of the head of the National Police of the Republic of Indonesia regarding the investigation of criminal acts. Chapter I. General Provisions. Article 1. In the regulation of the head of the National Police of the Republic of Indonesia, which is meant by the National Police of the Republic of Indonesia, hereinafter referred to as the National Police, is a state tool that plays a role in maintaining public security and order, enforcing the law, and providing protection, sufficiency, and service to the community in order to maintain domestic security. An investigation is a series of actions of the investigator in terms of and according to the way stipulated in the law to find and collect evidence that with that evidence makes light about the criminal act that occurred and in order to find the suspect. Investigators are police officials who are authorized by law to conduct investigations. An auxiliary investigator is a police officer appointed by the police chief based on the terms of rank and given certain authority in carrying out the investigative duties stipulated in the law. The supervisor of the investigator is a police officer who has the authority of investigation that structurally oversees the investigator/auxiliary investigator. A criminal act is an act against the law in the form of a crime or offense that is threatened with imprisonment, confinement, or fines. An investigation is a series of actions by investigators to find an event that is suspected of being a criminal offense to determine whether or not an investigation can be carried out in the manner stipulated in the law. Investigators are police officials authorized by law to conduct investigations. The suspect is someone who, because of his actions or circumstances, based on 2. Valid evidence supported by evidence, should be suspected as a criminal. A witness is a person who can testify in the framework of investigation, prosecution, and trial of a criminal offense that he hears himself, he sees for himself, and he experiences himself, including those he does not always hear himself, he sees for himself and he experiences himself. Expert information is information given by someone who has special expertise about what is needed to make light of a criminal case. Clues are actions, events, or circumstances that, due to its conformity, both between one and the other, or with the criminal act itself, indicate that their age. Clues are actions, events, or circumstances that, due to its conformity, both between one and the other, or with the criminal act itself, indicate that there has been a criminal act and who the perpetrator is. Information report is information about an event from the public or known by members of the National Police for investigation to find out whether the event is a criminal event or not. A report is a notification delivered by a person due to a legal right or obligation to the competent authorities about having or is suspected of a criminal event. A complaint is a notification accompanied by a request by an interested party to an authorized official to act according to the law that applies to someone who has committed a criminal offense that harms him. Notification letter for the start of investigation, hereinafter abbreviated as SPDP, is a notification letter to the chief prosecutor about the start of the investigation conducted by the police investigator. Notification letter of development of investigation results, hereinafter abbreviated as SP2HP, is a notification letter to the complainant about the results of the development of the investigation. Caught hand is the capture of a person while committing a criminal act, or immediately after, a while after the crime is committed, or a moment later called by the public as the person who did it, or if a moment later he was found to be a hard suspected object has been used to commit a criminal act that shows that he is the perpetrator or participated in committing or helping to commit the crime. Crime scene, which is hereinafter abbreviated as crime scene, is where a criminal act is committed or occurs, and other places where victims and/or evidence and/or witnesses and/or perpetrators related to the criminal act can be found. Evidence is a moving or immovable, tangible or intangible object that has been confiscated by the investigator for the purposes of examination in the level of investigation, prosecution and examination at a court hearing. The report of the results of an investigation is a written report made by the investigator that contains the results of an investigation into an event that is suspected of criminal offenses. A whistleblower is a person who informs and conveys about having or is suspected of a criminal event and is directly involved in the event. Preliminary examination is an examination carried out by the official carrying out the investigation supervision function based on a warrant from the supervisor of the investigator, who is authorized to the investigator or auxiliary investigator who is suspected to have committed a violation of the investigation process and/or investigation. Case degree is the activity of delivering explanations about the investigation and investigation process by investigators to degree participants, and continued group discussions to get responses/inputs/corrections to produce recommendations to determine the follow-up of the investigation and investigation process. Administrative registration of investigation is the recording of the activities of the investigation process manually and/or through the investigation e-management application. Electronic application of investigation management, hereinafter referred to as EMP application, is a website-based application used by investigators or auxiliary investigators in the investigation management system, as a means of controlling and database of criminal cases. Restorative justice is the resolution of criminal cases involving the perpetrator, victim, and/or his family and related parties, with the aim of achieving justice for all parties. Article 2. The scope of this regulation applies to the implementation of investigation functions in the POLRI environment. Chapter 2. Police Report and Investigation. Part 1 of the Police Report. Article 3. Investigators are authorized to receive reports/complaints either in writing, oral or using electronic media about criminal acts. Report/complaint as intended in paragraph 1, accepted at SATCR carrying the investigation function at the level MABES POLRI, or SPKT/SPK at the POLDIS/POLRIS/POLSEC level. At SPKT/SPK who received a report/complaint, placed investigator/investigator assist who is assigned to ensuring the smoothness and speed of making police reports. Conduct a preliminary review to assess the merit/absence of a police report, and provide optimal service for citizens who report or complain to police. After the initial study as intended in paragraph 3b, it is made receipt of the report, and police report. The police report as intended in paragraph 4b consists of Model A police report, which is a police report made by a member of the National Police who experienced, knew, or found directly the events that occurred, and Model B police report, which is a police report made by members of the National Police on reports received from the public. Police report as intended in paragraph 5, given numbering, as administrative registration investigation. Police report as intended in paragraph 5, handling can devolve to the lower level/level unity, taken over by upper level units, and delegated to other agencies. Article 4. After the police report is made, the investigator/auxiliary investigator who is in charge of SPKT/SPK at the POLDA/POLRAS/POLSEC level, or the reporting receiving official who is in charge of the SATCR carrying out the investigation function at the police headquarters level, immediately conducts an examination of the whistleblower in the form of news of the whistleblower witness interview event. Head of SPKT/SPK or receiving officials of reports at the level of the police headquarters, forwarding the police report and news of the interview of the whistleblower witness to officials carrying out the operational development function of the investigation for reports received in MAVs. Police Director of Police Criminal Investigation for reports received at SPKT Polda according to the type of case reported. Police Chief/Waka Polras for reports received at SPKT Polras, or Police Chief/Waka Polsec for reports received at SPK Polsec. Receipt of police report on SATCR carrying out the investigation function is carried out in accordance with the applicable provisions. Part 2 of the investigation. Article 5. The investigation was conducted based on reports and/or complaints, and investigation warrant. In the event that there is information about the existence of suspected criminal acts, an information report is made and an investigation can be carried out before the existence of a report and/or complaint with a warrant. Article 6. Investigation activities are carried out by crime scene processing, observation, interview, surveillance, disguise, undercover, tracking and/or research and analysis of documents. Research objectives include people, objects or goods, place, events/events, and/or activities. Article 7. Before conducting an investigation, the investigator is obliged to make an investigation plan. The plan of inquiry as referred to in paragraph 1, submitted to the investigator, at least contains warrant of inquiry, the number and identity of the investigator/investigator who will carry out the investigation, objects, targets, and targets of the results of the investigation, activities and methods to be carried out in the investigation, equipment and equipment necessary in the implementation of investigation activities, time required in the implementation of investigation activities, and the need for an investigation budget. Article 8. The investigator shall make a report of the results of the investigation in writing to the investigator. The report as intended in paragraph 1 contains at least place and time, investigation activities, the results of the investigation, barriers, and opinions and suggestions. The report as intended in paragraph 1, signed by the head of the investigation team. Article 9. The results of the investigation that have been reported by the investigation team must be carried out the title of the case to determine the alleged event. Criminal offenses, or not a criminal offense. The results of the title of the case that decides is a criminal offense, continued to the investigation stage. Is not a criminal offense, the termination of the investigation, and criminal cases are not the authority of the police investigator, the report is delegated to the authorized agency. In the event that the investigator's superiors receive an objection from the complainant to the termination of the investigation as intended in paragraph 2b, the title of the case is carried out to determine the investigation activities can or may not be upgraded to the investigation stage. Chapter 3. Investigation. Part 1. Investigation activities. Article 10. Criminal investigation activities consist of investigation, The start of the investigation. Forced attempts. Examination. Determination of suspects. Enforcement. Submission of case files. Submission of suspects and evidence, and termination of the investigation. In the case of investigation of minor crimes and violations, the investigative activities, consisting of examination. Notify the defendant in writing of the date, hour, and place of the trial. Submit files to the court, and present the defendant with evidence to the court hearing. Investigators in carrying out investigation activities as intended in paragraph 1, must carry out administrative registration of the investigation. Registration of investigation administration as intended in paragraph 3, is carried out centrally. Registration of investigation administration as intended in paragraph 3, is carried out centrally. Any development of case handling in criminal investigation activities as intended in paragraph 1, must be issued SP2HP. Article 11. Investigation as intended in Article 10 paragraph 1a, is carried out if no suspects and/or evidence has been found. Development of things, and/or unfulfilled evidence. Article 12. In the investigation process can be done restorative justice, if met the conditions. A material, including does not cause public unrest or no rejection of society. Has no impact on social conflict. The existence of statements from all parties involved not to object, and to waive the right to sue it before the law. Limiting principles. A. On the perpetrator. The level of error of the perpetrator is relatively not heavy, i.e. errors in the form of intentionality, and the perpetrator is not a recidivist. B. On criminal acts in the process. Investigation, and investigation, before the SPDP is sent to the public prosecutor. B. Formal, includes peace request letter from both sides. Whistleblower and reported. Statement of peace, certificate of dating, and resolution of disputes of the litigants, the complainant, and/or the family of the complainant, reported and/or reported family and representatives of community leaders, are known by the superior investigators. News of additional examination events of litigants after the settlement of cases through restorative justice. Recommendation of a special case title that approves the settlement of restorative justice, and the perpetrator does not object and is carried out voluntarily on liability and compensation. Part 2. Commencement of investigation. Article 13, 1. The investigation is carried out on the basis of police report, and investigation warrant. Investigation warrant as intended in paragraph 1b, at least contains the basis of the investigation, identity of the investigation team, the matter conducted by the investigation, the time of commencement of the investigation, and identity of the investigator as the commanding officer. After the investigation warrant is issued, the SPDP is created. Article 14. SPDP as intended in Article 13 paragraph 3, is sent to the public prosecutor, whistleblower/victim, and reported within no later than 7 days after the issuance of the investigation warrant. The SPDP contains at least the basis of the investigation in the form of police reports and letters. Investigation order. The time of commencement of the investigation. The type of case, the alleged article and the brief description of the criminal act being investigated. The identity of the suspect, and identity of the official who signed the SPDP. The identity of the suspect as intended in paragraph 2d does not need to be included in the SPDP if the investigator has not been able to establish the suspect. In the event that the suspect is determined after more than 7 days of the issuance of the investigation warrant, a notification letter of determination of the suspect is sent with the previous SPDP attached. If the investigator has not submitted the case file within 30 days to the public prosecutor, the investigator must notify the development of the case by attaching an SPDP. Article 15. Before conducting an investigation, the investigator is obliged to make an investigation plan submitted to the superiors. Investigators on a tiered basis. The investigation plan as intended in paragraph 1. At least contain the number and identity of the investigator, objects, targets, and targets of the investigation, activities and methods to be carried out in the investigation, characteristics and anatomy of the matter to be investigated, time required in the implementation of investigation activities, facilities and infrastructure required in the implementation of investigation activities, the need for an investigation budget, and completeness of the investigation administration. Part 3 of Forced Attempts. Article 16. Forced attempts include calling, arrest, detention, searches, confiscation, and mail check. Forced efforts as intended in paragraph 1 can be preceded by investigation. Article 17. The summons as intended in Article 16 letter A is made in writing by issuing a summons on the basis of a police report and an investigation warrant. Summonses to suspects/witnesses/experts are carried out in accordance with the provisions of the laws and regulations. Summonses to suspects/witnesses/experts are made through representative of the Republic of Indonesia where the domicile of the summoned person, for Indonesian citizens located outside the territory of Indonesia, or representatives of their country in Indonesia, for foreigners who are outside the territory of Indonesia. Summons as intended in paragraph 3, coordinated with the Division of International Relations. Police. Summonses to state officials are carried out in accordance with the provisions of laws and regulations. The suspect, who has been summoned for questioning for investigation and is not clear of his whereabouts, is recorded on the People's Search List and made a person search warrant. Article 18. Arrests as intended in Article 16 letter B, may be made by the investigator or auxiliary investigator against the suspect or by the investigator on the order of the investigator. Investigators or auxiliary investigators who make arrests must be equipped with an arrest warrant and a warrant of duty. In the event of being caught by hand, the act of arrest can be carried out by the officer without the equipped with an arrest warrant or warrant of duty. Arrests of foreign nationals residing in Indonesian territory should be notified to the embassy or consulate of the relevant country's representative in Indonesia, in coordination with the National Police's International Relations Division. In the event of an unauthorized arrest based on a pretrial verdict immediately released from the time the verdict is read or a copy of the verdict is received. Suspects who are suspected to be outside the territory of Indonesia, investigators coordinate with Bakar Marabanops Krim Polri to verify the submission of the red notice issuance process, which is carried out through the case title mechanism by inviting the Police International Relations Division. Article 19. Detention as intended in Article 16 letter C, carried out by the investigator against the suspect with a warrant of detention. The detention action is carried out in accordance with the laws and regulations. Administrative responsibility for the detained suspect rests with the investigator who issued the arrest warrant, and the responsibility for the maintenance and care of the suspect who was detained while in the prison is on the official carrying out the custody function and evidence. In the event of unlawful detention based on a pretrial ruling, the suspect is immediately released from the time the verdict is read or received a copy of the verdict. Article 20. The search as intended in Article 16 letter D, is carried out by the investigator/auxiliary investigator by equipped with search warrant, and search warrant from the court, except in very necessary and urgent circumstances. Searches of clothing and/or bodies against women are carried out by policewomen/civil servants of the police/women who are trusted and appointed for assistance by investigators/auxiliary investigators. Article 21. Confiscation as intended in Article 16 letter E, carried out by investigators/auxiliary investigators on objects/goods related to the case handled for the purposes of investigation. Investigators/auxiliary investigators who make seizures as intended in paragraph 1 must be equipped with confiscation warrant and confiscation permit from the Chief Justice, except in the event of being caught by hand. In the event of unauthorized seizure based on a pretrial verdict, immediately return the seized goods since the verdict was read or received a copy of the verdict. Confiscation is carried out in accordance with the provisions of the laws and regulations. Article 22. Letter examination as intended in Article 16 letter F, is the action of the investigator/auxiliary investigator to open, examine, and confiscate letters sent through post offices and current accounts, communication companies, electronic system organizers, freight forwarding services or transportation, if the goods are strongly suspected to have a relationship with the criminal case being handled. For the purposes of mail inspection as intended in paragraph 1, the investigator/auxiliary investigator may ask the head of the post office and checking office, telecommunications company, freight forwarding service or transportation to hand over to him the letter in question, and for that purpose must be made a letter of receipt. Examination of the letter as intended in paragraph 1, carried out with special permission granted by the head of the district court, except in very necessary and urgent circumstances and/or provisions of other laws and regulations. Letter inspection is carried out in accordance with the provisions of laws and regulations. Part 4 of the examination. Article 23. The examination is carried out by the investigator and/or auxiliary investigator on witnesses, experts, and suspects as outlined in the news of the examination event signed by the investigator and/or the auxiliary investigator who conducts the examination and the person being examined. The examination as intended in paragraph 1 aims to obtain evidence in the investigation process to get witness, expert, and suspect testimony as outlined in the news of the examination event. Examination of witnesses/experts/suspects who are abroad can be carried out in the country where witnesses/experts/suspects are located with appropriate and reasonable reasons, and has been called in advance and known by the Indonesian embassy in accordance with the provisions of the laws and regulations. 4. The examination of state officials who have become suspects is carried out in accordance with the provisions of the laws and regulations. 4. The examination of state officials who have become suspects is carried out in accordance with the provisions of the laws and regulations. 5. Against suspects who are not able to be accompanied by legal counsel is carried out in accordance with the provisions of laws and regulations. 6. Examination of children who face the law is carried out in accordance with the provisions of laws and regulations. Article 24. 1. For the purposes of proof, a confrontation examination can be carried out by bringing witnesses or witnesses with suspects. 2. Examination of confrontation as intended in paragraph 1, investigator/auxiliary investigator must avoid conflict. 3. In the case of testing the matchup of witnesses or suspects, the investigator/auxiliary investigator can reconstruct. Part 5. Determination of suspects. Article 25, 1. Determination of suspects based on at least 2 pieces of evidence supported by evidence. 2. Determination of suspects as intended in paragraph 1, is carried out through the mechanism of the title of the case, unless caught by hand. Article 26, 1. Suspects can be subject to precautions so as not to flee outside the territory of the Indonesian state. 2. In very urgent circumstances, 2 Investigators in the early stages can submit requests directly to immigration officials to prevent traveling abroad of people suspected of criminal acts and followed up in writing. Part 6. Enforcement. Article 27. After the completion of the investigation, a resume is made as an overview and conclusion of the results of the criminal investigation. When the resume is completed, the preparation of the contents of the case file is carried out, which includes the completeness of the investigation administration. Administration of investigation as intended in paragraph 2, consisting of the contents of the case file, and not the contents of the case file. Further provisions regarding administration. Investigation, regulated by the Police Kabareskrim Regulation. Part 7. Submission of case files. Article 28. Submission of case files to the public prosecutor is carried out after the enforcement in the investigation process is completed. If the case file is returned by the public prosecutor to the investigator, the case file is handed back to the public prosecutor after fulfilling the public prosecutor's instructions on the lack of contents/material of the case file. Part 8. Handover of suspects and evidence. Article 29. The submission of suspects and evidence is carried out after the case file is declared complete by the public prosecutor. If the suspect is not detained and is feared to be fleeing or uncooperative, for the purpose of handing over the suspect and evidence to the public prosecutor can be made arrest and detention of the suspect. In the case of a quick examination event that is a case of misdemeanor, or a case of traffic violations, the investigator on the authority of the public prosecutor for the sake of the law submits case files, evidence, witnesses, and defendants to the court. Part 9. Termination of investigation. Article 30. The termination of the investigation is carried out through the title of the case. Termination of the investigation can be done to meet legal certainty, a sense of justice and legal expediency. The termination of the investigation is carried out in accordance with the provisions of the laws and regulations. Chapter 4. Title of case. Article 31. The title of the case is carried out by title of ordinary things, and title of special things. Article 32. The title of ordinary case as intended in Article 31 letter A, shall be applied to determine whether or not a criminal offense, establishing suspects, termination of investigation, the distribution of things, and solving the constraints of the investigation. The implementation of the ordinary case degree can invite the supervisory function and legal function of the national police. The distribution of cases as intended in paragraph 1d, reported to the investigator's superiors on a tiered basis. Article 33. 1. The title of the special case as intended in Article 31 letter B, shall be applied to respond to community complaints from litigants and/or their legal counsel after an order from the investigator's superiors, reopening the investigation based on the pretrial verdict, and follow up on things that are of public concern. 2. Implementation of special case degree shall invite the supervisory function and legal function of the national police and experts. Chapter V. Technical assistance investigation. Article 34. Investigators in carrying out criminal investigations are supported by the technical assistance of investigations to scientific proof, scientific crime investigation. Article 35. Technical assistance of the investigation as intended in Article 34, among others. Forensic laboratory, used in the event that the investigator requires examination and testing of evidence that must be handled and/or special treatment. Identification, used in the case of investigators requires certainty of the identity of suspects/witnesses/victims of criminal acts and as a means of evidence. Forensic medicine, used in the event that the investigator requires the examination of suspects/witnesses/victims who must get special treatment/physical treatment. Forensic psychology, used in the case of investigators, requires the examination of suspects/witnesses/victims who must get special psychic treatment/treatment. Digital forensics, used in the event that investigators require examination and testing of digital evidence that must be handled and/or special treatment. Chapter 6. Supervision and Control. The first part of the executor. Article 36. Supervision and control of investigations is carried out by investigators superiors, and the officer of the investigation supervision function. Part 2. Investigator's supervisor. Article 37. The investigator superior, as intended in Article 36 letter A, is in charge of supervise and ensure that each stage of the investigation goes according to plan, ensuring the implementation of the investigation process and investigation effectively and efficiently, conduct analysis and evaluation of the results of investigations and/or investigations, checking the completeness of individuals to ensure the safety of investigators and investigators, helper in the execution of duties, assist in solving problems and obstacles faced by investigators/auxiliary investigators in the implementation of duties, and minimize and follow up on public complaints against investigations. Part 3. Investigative Supervision Function Carrying Officer. Article 38. 1. The official carrying out the supervisory function of the investigation as intended in Article 36 letter B, is tasked with conducting supervision of investigations and investigations in the police environment, conducting material examination and administration of investigations, conduct a preliminary examination of investigator/auxiliary investigator, and coordinate with surveillance functions outside the criminal resource function. Part 4 Goals. Article 39. Targets of supervision and control of investigations and investigations include investigators and investigators/auxiliary investigators, investigation and investigation activities, and administration of investigations and investigations. Part 5 Methods. Article 40. Methods of supervision and control of investigation and investigation activities, at least include administrative research and e-management investigations, tactical and technical supervision, assistance and supervision, and title of the thing. Article 41. 1. Supervision and control of investigation and investigation activities is carried out in routine and incidental. Routine supervision as intended in paragraph 1a, carried out by the supervisor of the investigator who has authority since the issuance of the investigation warrant and/or investigation. Incidental investigation supervision as intended in paragraph 1b, carried out by the office carrying out the investigation supervision function based on the warrant of the authorized investigator superior, if there are the existence of alleged violations/irregularities committed by investigators and/or auxiliary investigators in handling cases based on community complaints, or investigations and/or investigations of public concern. Community complaints as intended in paragraph 3a. The handling is carried out in accordance with the provisions of laws and regulations. Part 6. Supervision and Control Results. Article 42. 1. If the results of the investigation and investigation supervision are found to be violations in the investigation process and/or investigation conducted by the investigator and/or the auxiliary investigator as intended in Article 39 letter A, it is carried out. Construction, when committing a violation of procedures. The investigation process, if suspected criminal offenses are found, or preliminary examination, if found alleged violations of the Code of Ethics and Discipline. The investigation process as intended in paragraph 1b, based on the results of the title of the case and/or preliminary examination according to the orders of the superior investigators. If in the preliminary examination as intended in paragraph 1c, it is found that a violation of the Code of Ethics and/or discipline, it is delegated to the pro pam function to be examined in accordance with the provisions of the laws and regulations. Article 43. If the results of the supervision of the investigation are found to be violations of the investigation activities and/or investigation of criminal acts as intended in Article 39 letter B, conducted coaching of investigators and/or auxiliary investigators who commit violations and provide tactical and technical instructions to the investigation process and/or investigation. Article 44. If under the supervision of the investigation and/or investigation there is a violation of the administration as intended in Article 39 letter C, the investigative supervisory officer recommends to the investigator's superiors to provide guidance to the investigator and/or auxiliary investigator. Chapter 7. Evaluation of investigators/auxiliary investigators. Article 45. To measure the success of the investigation conducted by the investigator/auxiliary investigator, a performance evaluation is carried out through the EMP application. The investigator's supervisor in conducting supervision and control of investigation activities, carried out through the EMP application. Further provisions regarding the implementation of the EMP application system as intended in paragraph 2, are regulated by the Police Cabarruscrim Regulation.